Define the term company. Who can define the term company? Who can define the word company? A company, we can define it as a legal entity. A legal entity distinct from its members. The case of Solomon versus, the cases of Solomon versus Solomon. So that's where we derive the definition of the term company, that it's a legal entity distinct from its members. Now, types of companies. We have said a company is a legal entity distinct from its members, and then we proceed to look at the types of companies. When you talk about types of companies, one, we have chartered companies. And when you talk about chartered companies, these are companies that are formed through a charter. They are formed through a charter. For instance, a charter that is private universities. That is private universities. Private universities like KEMU, Kenya Methodist University, KCA is also private. They are given a charter to operate by the president. Are you together? And that's what constitutes a private university. Two is statutory companies. Or statutory corporations. And these ones, they are formed through a statute. They come to existence through a statute or a legislation. A legislation. This refers to government-owned corporations. That is government-owned corporations. So we've said that is for e.g. private universities, e.g. government parastatals. Like Kenya Power. Kenya Power and Lightning Company is a company owned by the government. Kenya Meat Commission, Kenya Broadcasting Corporation, all these parastatals of the government, they are also companies. They come into existence through an act of parliament. Act of parliament. So for instance, there is an act of parliament, Kenya Power and Lightning Company Act. So those statutory companies, that they come into existence through a legislation or an act of parliament. Are you together? Yeah. Then there is registered companies. They are registered in accordance with the Companies Act. Companies Act. And companies that exist through the Companies Act, they include, this is a question, there's a time the examiner had tested this question, we shall see it in one of the past papers. And now discuss 5 types of companies that come into existence through the Companies Act. One, we have private companies. Private. 2, public companies. 3, companies limited by shares. 4, companies limited by guarantee. And even unlimited companies. So your question is answered. So those are the major types of corporations. Now we've said chartered companies are companies formed through a charter, and it majorly refers to private universities. Are you together? Yes. Statutory corporations, we said they are created through an act of parliament and majorly government-owned parastatals. Registered corporations, we said companies, they come into existence through the Companies Act, and especially we've given examples. Now we are going to, for the purpose of this unit, company law, we are going to give more focus to registered companies. Are you together? Now we are going to start elaborating about private companies, public companies, limited by shares. Indeed, the whole of company law is about these companies. Now, what makes, for instance, let's start with the public companies. You said we have a public companies here. They come into existence through the Company Act. And what makes a company a public company? We can just discuss because we had already studied this. So a minimum number of 7. We can just discuss without me writing a lot. How many directors? At least 2 directors. The shares must be freely transferable. Do you understand what it means that the shares are freely transferable? What it means by that the shares are freely transferable is that a member who owns shares in a public company can have any other person, can transfer his shares to any member of the public, can transfer his shares to any member of the public. What does it mean? Shares with the private companies, are shares freely transferable? Shares are not freely transferable. What we mean by the shares of a private company are not freely transferable is that before you transfer, that you can only transfer shares to the existing member. You can only transfer shares to the existing member. Are you together? And therefore, shares of a private company, the transfer of shares of a private company is restricted. Are we getting? Transfer of shares of a private company is restricted. That you cannot transfer shares to any member of the public. You can only transfer your shares to an existing member. Are we together? And that gives rise to something we shall be discussing later on called preemptive rights. Preemptive rights means that it is the right to the existing member, that any member who wants to transfer shares, he must first offer those shares to an existing member. Are you getting? So that if you want to transfer shares, you cannot transfer those shares to anyone. You can only offer those shares to the existing member. And that is a right enjoyed by who? By members, by existing members of a company. Are we together? So we have said it has a minimum number of 7 and no maximum, at least 2 directors. Its shares are freely transferable. It must have a statutory meeting. Do you know what is a statutory meeting? It's one of the meetings, statutory meeting. With the Companies Act 2015, this is not a requirement. But what happened is that once a company is formed, before 2015, it was required to hold its first meeting within 3 months after formation. It was required to hold a meeting within 3 months after the formation. And that was what was called statutory meeting. So it is the first meeting of a public company. It's the first meeting of a public company. Then it must publish accounts. It must publish accounts. Then after acquiring certificate of incorporation, it must acquire the certificate of trading. It must also have a company secretary, and a public company is going to include at the end of its name the word PLC. That's why you find Safaricom siku hizi inaandikaga majina Safaricom PLC. Si mnaonanga hivyo? Safaricom PLC. So don't confuse, don't start saying that a public company is a government. No. A public company, it's a company whose shares are freely transferable. It refers to these companies which have floated their shares in a Nairobi Stock Exchange. For instance, Equity Bank, is it a private company or a public company? Equity Bank. These big companies are public companies. Shares of equity, si watu wako nazo huku nje. Si ndio? Are we getting? Safaricom is a public company. Equity Bank is a public company. These big companies, most of them are, sasa hizi zetu za kujitegeza, hizi za kutafuta tenders huku nje, si hata nyinyi mko na kampuni. I'm so sure you have already registered some companies. Sasa hizi kampuni dogo dogo za briefcase, most of them are the ones that are private companies. Are you together? The public companies are highly regulated. They are highly, are we together? Yes. Now, examiner atakuuliza, discuss 5 disadvantages. Or you've been told XYZ wants to form a company, and he's asking you for advice on whether to do a public or a private company. Tell him why he should not do a public company. Utamwambia nini? Tell him why he should not do a public company. Yes? Tell him why he should not do a public company. Yeah, one is capitation. It's huge capitation. That's true too. Yes. Yeah, indeed, these are the answers. For instance, a minimum of 7 members. Is that not a disadvantage? It's a disadvantage in this sense. How, before you get 7 people for you to form a company, it's a task. Are you together? See, unajua ile private utachukua wife yako mwende mregister. Indeed, by the way, private company, with the Company Act 2015, one person can form a company. Are you getting? One person can form a company, as long as he has a company secretary. But this one, how many members? 7. Do you think that's not a disadvantage? Sindio? Look at the second one. The shares are freely transferable. It's a disadvantage because you can surrender the control of the company to anybody. For instance, somebody approaches me and he gives me some millions, and I have a lot of shares in XYZ company, and niambie mimi nataka control kwa ile company, nipatie hizo shares zako. Are we together? Are you getting? So that means that, but with the private companies, the transfer of shares is restricted. You can only give to the existing members. Are we together? I want you to see it in a broader perspective, because the examiner will want you to make arguments the way. Now, you just, maswali ya company lo hakuna answers. Most of the questions answers it kwa notes. Usiende ati utafute answers kwingine. It doesn't require you to think outside the notes. Sawa? Are you getting? Yes. So utapata hizi ndio answers ziko kwa marking scheme, umeandika answers zako. So you stick to these no answers. So the examiner will twist a question, but he's looking for these answers. Are we together? Yes. The third is the disadvantage. It must publish annual accounts. It's a disadvantage. Okay, it's a disadvantage. What happens with public companies is that they are highly regulated by the government because public has invested in them. Public has invested in them. So members of the public have invested shares in Safaricom. So Safaricom, the government wants to protect the public investments. And therefore, those companies are highly regulated. Once you publish accounts, your competitor will see how much you've made. Sindio? You made losses or profits. After acquiring certificate of incorporation, it must go ahead and acquire the certificate of trading. That's also a disadvantage. It must have a company secretary. That comes with a cost. Sindio? Are you together? So the examiner may twist questions. He may ask of features, he may ask of disadvantages. Okay? Yes. A private company. A private company is a company with the following features: a minimum of number of 1 and a maximum of 50. Sawa. Requires how many directors? Why I'm not writing is because it's like you had done all this. You had done all this and we have an internet outage. Okay. Yes, Lawrence. So I'm going to move very fast and maybe discuss the way questions may be tested because you had already done this. So restricts the right to transfer shares. We've said you can only transfer shares to the existing members. Are we together? Prohibits any invitation to the public to subscribe for its shares. Does not issue a prospectus. We shall discuss the word prospectus later. Not mandatory to publish its accounts and required to have a company secretary if it has a share capital of more than 5 million shillings. A private company must include the word limited or LTD at the end of its name. So what we are saying, the examiner may also ask you, why should you tell him to form a private company or advantages? The good thing about private companies, they are not highly regulated. They are not highly regulated. And to prove that they are not highly regulated, from the features. So those features that are there are the advantages of a private company. Now, a public or the private company may be classified as companies limited by shares or company limited by guarantee. And what it means by company limited by shares is that the liability of members is to the extent of the shares you hold in a company. Your liability is to the extent of shares you hold in a company. That's what it means by companies limited by shares. The liability of members is to the extent of the shares you hold in a company. So meaning that even if XYZ company, XYZ Limited is indebted and owes debt at 80 million, and my shares are worth 20,000, my liability is up to 20,000. Are we together? Even if I'm the richest person, even if I'm the richest person in Kenya, the only money I can pay to meet the obligations of XYZ Limited is 20,000. Are you together? Yes. Now, companies limited by guarantee. Hii swali ni common sana hii. Utaulizwa describe 3 reasons, describe features of a companies limited by guarantee. Na kampani lo vizuri unapatiwa kwa 6 marks. Unapatiwa ngapi? 6. So each point is how many marks? 2. So what makes a company to be said to be limited by guarantee? 1, does not have a share capital. So that statement gives you 2 marks. It does not have a share capital. 2, liability of its members is limited by the company's article to the amount that the members undertake by those articles to contribute to the assets of the company in the event of liquidation. So in other words, the liability of members is limited by the amount they have guaranteed to the company. You can put it that way. The liability of members is to the extent of the amount they have guaranteed to the company. Can I give you an example of companies limited by guarantee? Children's home, charitable organizations, NGOs. What happens with those NGOs and charitable organizations is that they do not have a share capital. So when we are forming them, we agree, for me, this children's home, I'm one of the, yes, company law. Company law, welcome. When we are forming the children's home, for instance, we want to form a foundation, I'll say that I have guaranteed this company 2 million shillings. So my liability in that company is up to 2 million shillings. So even if it owes creditors 20 million, I can only pay how much? So meaning the liability of the members is to the extent of the amount they have guaranteed the company. Are we together? And number 3, it's yes.
When somebody does like 2 million,
no, what the charitable organizations is what you refer to as not for profit or non-profit company, non-profit organizations. So we are doing them for the sake of the humanity, like the way people form foundations. For instance, talk of foundations like a Kalonzo Musyoka Foundation. Kalonzo Musyoka is one of the members. Probably he has guaranteed that Kalonzo Foundation 10 million shillings. So even if the company was to go bankrupt, the extent of the amount, the only amount Kalonzo can contribute towards meeting its financial obligations is 10 million. That's clear? Yeah. Then its certificate of incorporation states that the company is limited by guarantee. Hizo ni answers rahisi sana kupata 6 marks, ndio? It doesn't have a share capital. The members, the liability of members is to the extent of the amount they have guaranteed the company. And the third one is the certificate of incorporation states that the company is limited by guarantee. Companies limited by guarantee in Kenya are immediately registered for the purpose of operating non-profit organizations that require a legal personality. Unlimited companies. These are companies where members' liability is unlimited. Such members may lose their private assets in case the company is declared insolvent. So what we are saying by limited is that the case of Solomon versus Solomon. For instance, in the case of Solomon versus Solomon, Solomon was a very rich man. He was very rich. But now Solomon Limited became bankrupt. And the case even went up to the highest court in UK. And the court ruled that Solomon and Solomon Limited are two distinct persons. Indeed, this is a classical case that gives us the features of a company. Indeed, when we shall be talking about the characteristics of a company, we are borrowing from who? When we define the term company, we are borrowing from who? So the court ruled that Solomon and Solomon Limited are two distinct persons in the eyes of the law. So Solomon is very rich, but now the creditors wanted to recover the debts of Solomon Limited from Solomon. Are you together? But the court ruled that Solomon and Solomon Limited are two distinct persons in the eyes of the law. Are we together? And the only amount they could recover from Solomon is the amount, is the shares he had in Solomon, the amount of shares he had not paid in Solomon Limited. Tunaelewana? Yes. So that's what we're saying, that you cannot, with a limited company, creditors cannot recover their money from the private assets of the members. Are you together? Yes. They can only recover the amount up to the extent of the amount the members have guaranteed the company. Are we getting? Now, with the unlimited companies, members may lose their private assets because there is no limitation to the extent in which the creditors can recover their what? The money they have credited the company. Are we together? I hope that's understood. Now, difference between public and private companies. Me, I feel it's just a repetition of what we are discussing. That table, discussed the senior. Are we together? So registered and statutory. Registered is formed through the Companies Act. Statutory is formed through an act of Parliament. Then governed by directors. The other one is owned by who? Government. Na nimesema hivi, msianze confuse ati public, mwanze kuona public company. So tumesema public company, that's the whole thing we usually think. Public company ni zile zimeunwa na serikali. Za serikali tumeziita nini? Statutory. Za serikali tumeziita statutory. Tumesema public companies are companies whose shares are freely transferable. Na tukasema ni hizi kampuni kubwa kubwa, si ndio? Equity, Safaricom, gani ingine? KCB, hizo zote, hizi bank zote, hizo zote ni public companies, si ndio? Even public universities are statutory companies. Public universities are statutory, whereas private universities are chartered. Yes. Can only engage in transactions stipulated in memorandum and articles of association, can only engage in transactions set by the statute. So with the registered companies, their constitutive documents are memorandum of association and articles of association. Yeah. Yes. No. It must either be either one. So Kengen is a government. Kengen is formed through a Companies Act. Because with the Kengen, it's owned by the government. I'm so sure Kengen doesn't have, does it even, with the registered companies, it must fall either under this. Where would you put, it can't fall either, it's not a Kengen, is a statutory company. It's purely owned by the government. So it came into existence through the statute. Sindio? What about the difference between a company and a partnership? One, partnerships. Are partnerships, do they have limited liability? Partnership ni wewe na mimi, we come together to do business. Na ndio unaona hata mkifanya FA mnasoma pale chini kila mtu anapatiwa pesa yake, si ndio? Are you together? And then wewe uende ukalipe tax yako ukafanya hesabu zako kama umefanya. Are you getting? But companies, we do a 30% corporation tax. Si ndio? With companies they do 30% corporation tax. What are we saying? A company is a person. A company is a person. Kwa hivyo wewe ukilipa tax yako, si ati unalipia company. Company inajilipia tax ya, because in the eyes of the law, a company is a legal entity distinct from its members. Are you together? Meaning, kampuni inalipa tax yake na mimi kama mimi Peter, mimi niko na Peter Limited. Peter Limited kwa sheria analipa tax yake 30% na mimi Peter. Are you getting? But kwa partnership, do we do that? Si kila mtu anapatiwa pesa yake ya profit, alafu uende ujilipie tax kulingana na profit zako, si ndio? Yes. So a partnership is not a legal, does not have legal personality. Are we together? Yeah, it's a legal person distinct from its members. That's a company. A partnership is not a legal person in the eyes of the law. Membership 1 to 50 members for private and 7 to no maximum. Minimum of 2 and 20 persons for partnerships. Registered under the Companies Act, registered under the Partnership Act. Capacity to own property. Property is jointly owned by members. Sawa. Property for partnerships is jointly owned by members. Managed by directors, managed by partners. A legal requirement to hold AGM is not a legal requirement. Has perpetual succession. You know what it means by perpetual succession? It's the opposite of, so death of members does not lead to the dissolution of the company. Are we together? That's what it means. With the company, it has perpetual succession. Even death, even members die, even if they become bankrupt, even if they become bankrupt or they become insane, that one does not lead to the dissolution of the company. But death, bankruptcy, and insanity will lead to the dissolution of the partnership. Death, insanity, or bankruptcy of the partners will lead to the dissolution of the partnership. Are you together? Yes. Then, doctrine of attravias. Attravias means beyond power. Attravias means beyond power. Now, with the company, it can only engage into activities stipulated in the Memorandum of Association and Articles of Association. Are we together? For instance, KCE College Limited can only engage into activities of education. It cannot go into activities of providing tax consultancy. Nini. Are you together? You have to stick to you have to do activities as stipulated in the Memorandum and Articles of Association. But partnerships can do other things. Are we together? Partnerships are not restricted. Then auditors must appoint auditors. It's not a legal requirement. And liability limited by shares or guarantee, not limited. Tuko pamoja hadi hapo? Si tumeelewa? Features of a company. Another question, ndio nasema ni lazima tujue venye maswali. Discuss 5 consequences of incorporation. To incorporate means to register a company. It means to register a company. It may also mean to convert a partnership into a company. So the moment now you have converted a partnership into a company, for instance, a partnership has been converted into a company, what are the consequences? Unaelewa? Tunaelewa? Unaulizwa, XYZ partnership has been converted into a company. Discuss 6 consequences. What happens? It has become a company. The first consequence is the definition. It becomes a legal entity distinct from its members. Or the examiner may even ask, discuss the consequences or effects, the legal effects of the case of Solomon versus Solomon. The answers are these ones. They are the same. Are you together? Because from the case of Solomon, we said Solomon was a very rich man. Now, the creditors went to sue Solomon to pay the debt that was owned by Solomon Limited, so that because Solomon Limited was bankrupt, and they wanted to recover the money from who? From Solomon. But they were not able. Because why? Why were they not able? Yeah? Because of legal personality. Solomon is distinct from who? Solomon Limited. Solomon Limited and Solomon are two distinct persons in the eyes of the law. Now, the consequence, separate legal existence. That's what we are saying. That a company is a legal entity separate and distinct from its members. Are you together? That's number one. Two, capacity to own property. So because it has its own legal personality, it can own property. So meaning the property of Safaricom Limited are not property of anyone. They are property of who? Safaricom Limited. Contractual capacity. That when you enter into a contract with a company, you have not entered a contract with its members. You've only entered that contract with who? Simnona zinaidiana, sindio? See, a person can be able to enter into contracts, sindio? So it gives contractual capacity to sue and be sued. When you sue a company, when you sue Solomon Limited, you've not sued who? Solomon. Are you together? Then perpetual succession. How did you say perpetual succession? That the death, insanity, and bankruptcy of the members does not lead to the dissolution of the who? Of the company. Common seal. Now, since a company does not have a hard to sign, it authenticates its documents through the common seal. Are you together? Or it authenticates, it assigns its document through a common seal. Limited liability. I think we've discussed that members' liability is to the extent is either limited by shares or guarantee. And then independent management. Shareholders are not involved in the management of the company. It is the directors who are involved in the management of the company. Now, we look at the holistic disadvantages of a company. Now, we had talked about the disadvantages of a public. Did you talk about the disadvantages of a public company? We have discussed them. In other words, we are looking at the company, public company. Why I should not do a public company and then I should do a private company. It has its own limitations. But now this one is disadvantages of a company. The examiner may tell you to explain to XYZ why he should do a partnership and not a company. One of them is that it is expensive to register a company because registration involves what are these legal costs? You need to prepare the memorandum of association, the articles of association, and you need the services of a lawyer to prepare those documents. Are we together? Yes. Two, complicated procedures. Complicated procedures or complex procedures. The same thing. The procedures of forming a company, you still need the services of a who? Of a lawyer, because they are very complex. Are we together? Indeed, tutaenda pale kwa registrar, akwambie sasa, we need the nominal share the nominal form, the CGCR what, they all be filled, and akwandikia hapo, get your lawyer to do that for you. Are we together? It's very complex. Two, publicity or lack of confidentiality. For instance, you see the memorandum of association. If today I want the memorandum of association of Safaricom Limited, I can get it. Even the articles of association. I'll go to the registrar of companies here at Harambee House, and I'll tell him that I want the memorandum and articles of association of Safaricom Limited. He will tell me to pay the photocopying cost, and he will give it to me. Are you together? Those documents are public. Memorandum and articles of association of any company are public. The same thing, annual accounts, when you publish them. See, that is lack of confidentiality, isn't it? Yes. For high taxation, you can imagine that 30% and that 7.5%, you've done tax, so you understand. And then participation in management. Participation in management, what it means, remember we had public companies, their shares are freely transferable. Their shares are freely transferable. So what if I acquire the majority shareholding? So I'll have the majority shareholding. I do not, for instance, we have formed a company, two of us, and then someone else to come and acquire the majority shareholding from her. So he becomes one of the person to manage the company. So meaning we surrender the management. And the doctrine of ultra vires, means beyond power. We had said that the company, it cannot act beyond the power stipulated in the articles and the memorandum of association. But a partnership can do what is, can undertake any business. Are we together? Now, another type of a company is corporation sole and corporation aggregate. Corporation sole and corporation aggregate. Now, there's a time now, I remember there's a time people were laughing at the daughter to the president because she said there is an office of the first daughter. Sindio? Now, what happens is this. Now, talk about the office of the president. You see, office of the president is do you know it's a company? Are you together? Office of, for instance, talk of the office of the president is what we call, for instance, office of the bishop, office of the attorney general, office of the president. Most of these corporations they start with the office of the something. Are you together? Now, the Constitution of Kenya has established an office of the president. It has established an office of the president. And the whole Constitution of Kenya stipulates that that office can only be held by one person at a time. So that's what makes something a corporation sole. So it's an office distinct from the owner and can only be occupied by one person at a time. So it is distinct from the owner. So the office of the president is distinct from the president. Are you together? And it has all the characteristics of a company. So the examiner, if he tells you, discuss 5 characteristics of corporation sole. The only characteristic that it distinguishes it from other characteristics is that it's an office distinct from its owner and can only be occupied by one person at a time. It has all the other characteristics. Can that office own property? Senior, can sue and be sued. So when you sue the office of the president, you have not sued the president. Sawa. Contractual capacity. Can, for instance, the contract that the former regime, that is the government of President Uhuru Kenyatta, entered into under the office of the president, President Ruto will continue with those contracts. Are you together? Because they were not contracted by Uhuru mwenyewe, but they were contracted by the office of the president. Are you together? So meaning it has all the features of a company. Are you together? Yes. That's why we say it has the following features: legal personality, can own property, can enter into contracts, perpetual succession, can sue and be sued. Yes. Who? No, but the government is not a company. The government of Kenya, government of Kenya is a company because it can own property, it can sue and be sued, but Sasa, it's not a company with the shares. So for him, he said it's a company with the shares, and the only share, the government of Kenya is a company with the shares, and all of us are shareholders. But Gachagua now said only those ones who voted for UDA are shareholders. Yeah, he was right. It's a statutory company, but now telling us it has shares and we don't have shares in that company. Yeah. So corporation aggregate is the opposite. So with corporation sole, we've said it's a company it's a company that can only be occupied by one person at a time. and the office holder are distinct from one another. Now, with the corporation aggregate, it's a legal entity formed by two or more persons. For instance, did we talk about chartered, statutory, and registered companies? Are we together? So those are examples of corporation. Those are examples of corporation aggregate. Those are examples of corporation aggregate. They have the same characteristics. For instance, perpetual succession, capacity to contract, to own property, and can sue and be sued. Are we together? Now, we look at holding and foreign company. Holding and foreign company. Hii mtasoma kwa financial reporting. Sawa. Now, the examiner at pia napedanga hii swali. Describe circumstances in which a company is deemed to be a holding company of a subsidiary company. Describe circumstances when a company is deemed to be a holding company of a subsidiary company. Unapatiwa 6 marks. Now, the explanation, a holding company is we usually refer to it as the parent company, and the subsidiaries. So the subsidiary is a company that is under control of another company called holding company. Are we together? Are we together? A subsidiary company is a company that is whose activities and management are controlled by another company called the holding. Is that explanation understood? That a subsidiary company is a company whose management and activities are controlled by another company called the holding company. Now, the answers to the question I have asked, when a company is deemed to be a subsidiary of another, these are the answers. You have them in your notes. The holding company controls the majority of the board of directors. So you find that most of the board of directors in the subsidiary are also sit in the board of the holding. Can I give you an example? Do you know National Bank of Kenya? Is it a subsidiary of KCB? Sawa sawa. So venye National Bank ilikaa kama inaanguka, ikachukuliwa na nini? Na KCB. So you find that most of the majority of the board of directors, indeed over 50%, majority of the board of directors who sit in the National Bank of Kenya board come from where? From KCB. Are we together? Yes. Number 2, the holding company owns more than half in nominal value of equity share capital of subsidiary. So ukisoma mtu anafanyanga ni lazima ufanye some things that will help you to remember. Moja tumesema directors, si ndio? Ya pili tumesema shares. So majority of the board of directors come from the holding company. The majority of the shares are owned by the holding company. Majority of the equity shares, that is the ordinary share capital. And if a subsidiary of another company, which is that of other company subsidiary. So in other words, what we are saying is that if A is the holding, B is a subsidiary, and C is a subsidiary, B is a subsidiary of A, and C is a subsidiary of B. Then even C is also a subsidiary of A. Are you together? Are you getting? So if this company is a subsidiary of another one, it's also a subsidiary of the holding. Is that point understood? Foreign companies are companies registered outside Kenya, but they have operations in Kenya. Foreign companies are companies registered in Kenya, but they have their operations in Kenya. Are you together? Yeah, we also call them companies incorporated outside Kenya, but they operate in Kenya. Foreign companies are companies incorporated outside Kenya, but they have their operations in Kenya. But they have their operations in Kenya. Is that understood? Unincorporated associations. Unincorporated associations are those associations that have not been registered under the Companies Act. So they are, but they have been registered under other laws. They have been registered under other laws. They include trade unions, societies, partnerships, and staff unions. For instance, COTU is not registered under the Companies Act. It is registered under the Workers Act something. Are we together? Yes. Whose primary objective is to, so for instance, trade unions are organizations whose primary objective is to regulate the relationship between employer and employees. For instance, COTU, NA, TTC. A registered trade union has special privileges. Though it is not incorporated, it has certain special privileges. It can be sued under its registered name. Are we together? Though we have said to sue and be sued, you must be incorporated. With the trade unions, they have that privilege. It is immune from civil prosecutions, and all properties of trade unions are vested on trustees for benefits of its members. Sana sana ile swali inakujaga ni hii ya cooperative principles. Hii inakujanga sana. Cooperative principles. Cooperative societies. Mnajua hii cooperative societies, for instance, tuongee kuhusu wakulima wa maziwa wa KCCU, si ndio? Ni Kenya Cooperative. Hii ya coffee farmers inaitwa nini? Kenya Coffee. Si coffee farmers definitely hata kule mmetoka, so wako na cooperatives, si ndio? What is the benefit of those cooperatives? Ni lazima muelewe kabla tu nini. What is the benefit of those cooperatives? What do they do? Do they educate farmers? Sisi wana educate about the emerging technologies in farming. Si ndio? So information, do they give information? Hizo cooperatives ndio zimekuja, they come together hata kutafuta market ya coffee abroad, si ndio? So those cooperatives are necessary for information, for education, for marketing. Si umeelewa sasa venye tunasema kuhusu cooperative societies, si ndio? Especially the farmers. See, it's basically a independent organization of people who have come together voluntarily to meet a common economic, social, cultural needs. Cooperative principles: 1, voluntary and open membership. Voluntary and open membership. Yes. 2, democratic membership control. 1 man, 1 vote. With those cooperative societies, people do not, unlike companies. Companies, are they democratic? Companies, your voting power is based on the number of shares you hold in that company. Are you together? So meaning, kama mimi niko na 60% in this company, my voting power is 60%. Kwa hivyo mimi naweza sema nani atakuwa director wa hii kampuni na nichague kila mtu, na nyinyi wote tunawaita nini? Minority shareholders. Nyinyi wote ni minority, and me alone with the 60%, I'm the majority shareholder. Are we together? So there is no democracy in companies. There is no democracy is where we say 1 man, 1 vote. Na sasa imeadiwa na 1 man, 1 vote, 1 shilling. Ndio? Niyo ni mambo ya BBI, eh? Then autonomy and independence. Education, hiyo imeandikwa trading, si trading, ni training. Kwa handout, mtaenda mbadilisha, sawa? It's supposed to be training, we shall change and information. Cooperative among cooperation among cooperatives, and concern for the community in general. So those are the principles that guide cooperatives. 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 Now we look at advantages of cooperatives. Tumesema 1 is mobilization of savings. SACCOs. SACCOs are also cooperatives. Sawa. Mobilization. SACCO stands for savings and credit corporations, or SACCO, savings and credit cooperatives. Savings and credit cooperatives. So meaning one of the benefits of cooperatives is mobilization of savings and advancing credit to its members. Advancing credit to its members. Marketing of agricultural produce, for instance, coffee farmers, they market their produce through cooperatives. Provision of credit to its members. Creating employment both directly and indirectly. Training, education, and information to its members. Collection, transportation, and processing of agricultural produce. Are we together? Yes. See, now, types of cooperatives. When we have primary cooperatives. And primary cooperatives ni kama hizo za farmers. Now, members in the farmers will join them as individuals. Are we together? Then those cooperatives, those primary cooperatives also come together. Those primary cooperatives also come together to form cooperative unions. They form cooperative unions. And now those cooperative unions may also come together to form apex. Are we together? So we start from primary cooperatives to cooperative unions to apex. Now, difference between cooperatives and companies. One, cooperative unions, they are created, regulated by society. They are created and regulated by Societies Act. They are created and regulated by Societies Act. With the companies, they are regulated by the Companies Act. Formed by at least 10 members, that's cooperative societies, but the other companies, they are formed by at least 1 member for private and 7 for public. It is not a legal person. The companies are legal person. Main purpose is to serve members, and then companies, the main purpose is to serve public. Cooperative societies, they are managed by management committees. They are managed by management committees. The companies are managed by board of directors. Cooperatives, they are registered by Commissioner of Cooperative Development. They are registered by Commissioner of Cooperative Development. The other ones are registered, companies are registered by Registrar of Companies. Cooperatives, they are democratic, 1 man, 1 vote. Whereas companies, members voting is based on the number of shares held. Members have unlimited liabilities for cooperatives, whereas limited companies, members have companies members have limited liability, either limited by shares or by guarantee. Now, let's talk about legal, the veil of incorporation. The veil of incorporation, that's what we're going to discuss in the next subtopic. The veil of incorporation simply means the legal, if the examiner may test you and ask you, discuss the term veil of incorporation, 3 marks. It's the principle that a company is a legal personality distinct from its members. So this veil is like other books will describe it as a curtain or as a shield or as a shield. So in other words, like this curtain, when a curtain covers me, I don't want to know what is. For instance, a curtain will separate Solomon from who? Solomon Limited. Are we together? Or a shield will protect Solomon from the death of Solomon Limited. Are we together? A veil is a cover. So mimi mambo ya Solomon Limited, mimi sishughuliki kama Solomon. Are we together? So meaning veil of incorporation is the concept of legal personality that a company is a legal entity distinct from its members. Have you understood that? But now, in certain circumstances, this veil can be lifted. This veil can be, and now we shall talk about lifting of veil of incorporation. Now, lifting of that veil of incorporation means circumstances in which a member can be held liable for the activities or for the acts of the company. Circumstances in which members can be held liable for the acts of the company. Or lifting of the veil of incorporation also means disregarding the veil of incorporation. Disregarding the veil of incorporation. Ignoring the veil of incorporation. Or ignoring that legal principle of legal personality. Tuko pamoja? Are we together? Nice swali na one examiner. Kuna time alikuwa ameuliza na akauliza, examiner had tested sometimes back, I think it was test 12, it's usually 6 marks or 12 marks. Sawa. Now, lifting of the veil of incorporation, you understood what it is, or ignoring the veil. Are we together? You don't care. Now, you don't start saying that because sasa ukatae kulipa taxes kwa KRA na unatumia kampuni, alafu unaenda kuambia KRA. No. Those debts belong to Peter Limited. KRA will come for you as Peter. Are you together? Are we getting? Yes. Au watu wengine wana form company ati XYZ Limited ili waanze mambo ya kuibia money laundering na corruption. Wengine child trafficking. Halafu sasa wakikamatwa, no. That is Peter Limited doing that. Are we together? The court will disregard the veil of incorporation in those circumstances. So there are two circumstances in which the veil can be disregarded, either by the statute or by the court. Either by the statute or by the court. Now, with the statute, it is where the Companies Act, this statute refers to the Companies Act. The Companies Act, where you do not meet the conditions stipulated by the Companies Act. For instance, the Companies Act states that a public company should have how many members? According to the Companies Act, how many members for public companies? 7. Now, let's say in the unfortunate event, one member dies. Probably in that company, they are not even 10, they are 7, exactly 7. And one member dies, they will remain 6. And they continuously do business for a period of 6 months as 6 members. At that point, the members will be held liable because they did not meet the requirement of the Companies Act that of the minimum membership, or the statutory membership. Are we now getting what I'm trying to say? So under the statute, so we've said it can, for instance, the question, you'll see your past papers, we shall see them. There is a time the examiner had asked, discuss these circumstances under which the veil of incorporation can be lifted by the statute, 6 months, by the court, 6 months. Sawa. So by the statute, one of the reasons why the statute or the Company Act is reduction in number of members. Go back to your handouts and you see reduction in number of members below the statutory minimum. For instance, we've said a public company should have a minimum of 7 members. So if you do business below the statutory minimum membership for more than 6 months, you'll be held personally liable as members. Are we together? Yes. Where the membership of a company falls below the statutory requirement and members do business for more than 6 months, they are held personally liable. 2, non-publication or misdescription of the company's name. Another requirement of the Companies Act is that the company should, there is a law, under the Companies Act, companies are required to publish their names in all its documents. Are we together? Indeed, a company is also required to put its name conspicuously in all its physical locations. Now, if a company does not publish its name, so that's why I say non-publication. Now, mimi niandike kwa Peter Limited, niandike na nisign, na sijaandika under the Peter Limited, I will be held personally liable. Are we together? Au niandike, instead ya kuandika Safaricom, niandike Safaricom. That's misdescription. Kampuni Safaricom itaruka iseme hii si Safaricom. Hii ni Safaricom kweli? See, this is misdescription, si ndio? Yes. So the Company Act requires the company to publish its name. On all official publications, for instance, checks, invoices, bills of exchange, and failure to comply with those provisions may lead to the lifting of the corporate veil. Are we together? Yeah. Number 3 is group accounts. Let me explain that point. With the group accounts, we said that mkisoma FR mtasoma muambiwe that a group, that when a company is preparing its financial statements, it should prepare its statements as well as those statements of its subsidiaries. Sawa, iziweke pamoja. Si ni kweli? Lakini sasa kwa company, now that is a requirement of the Companies Act. That's a requirement of the Companies Act, that when it's preparing the financial documents, it should prepare its financial documents as well as those of its subsidiaries. Now, that one, hamuoni kama company imenyimwa its legal personality, ile subsidiary ni kama inatritiwa kama mtoto wa nini? Wa holding. Are you together? So, in other words, that company is not being given its independence. That subsidiary is not being treated as a legal person on its own. Are we together? The subsidiary is not being treated as a legal person on its own. Are you together? And that one is the argument by the lawyers is that it amounts to lifting the veil of incorporation. It also amounts to lifting the veil of incorporation. And that one is by the law. It is the statute that requires that when a company is preparing its financial statements, it prepares its own financial statements as well as those of the subsidiary. Tuko pamoja? Yes. Number 4 is investigation of the company affairs by inspector appointed by court. Investigation of the company's affair by an inspector appointed by court. In certain circumstances, the law stipulates that if in the event the company is undertaking business and there is a reason for the inspector to believe that the company is not protecting the interest of the creditors. The inspector at the courts, if I go and sue a company, the court is of the opinion. The court is of the opinion that we need to protect the investments of the shareholders. The investments of the shareholders, the court is empowered by the statute to appoint an inspector. The court is empowered by the statute to appoint an inspector to undertake further inspection. That inspector will not only investigate the company, but will investigate the company and its members. Are you together? The inspector will not only investigate the company, but will investigate the company and its members. And that also amounts to lifting the veil of incorporation. Yes, that once an inspector is appointed by court, he will investigate both the company and its members. Na mujue mahali pote tunagusa members, that one amounts to lifting the veil of what? Of incorporation. Then investigation of company's membership by inspector appointed by registrar of company. The law also empowers, it either empowers the court or the statute empowers the court or the registrar of companies to appoint an inspector. Are we together? Then number 6, takeover bid. Takeover bid. So in a takeover bid, let me explain this point. In a takeover bid, 90% of the shareholders are required to approve the takeover bid. 90% of the shareholders are required to approve the takeover bid. Sasa, 90% washa approve. How do you tumeita nani? Tumesema wale wengi tunawaitanga nani? Ni lazima mjue hii majina. Tunawaita nini kwa law? Majority shareholders. Majority shareholders. Na hawa 10% wanaitwa nani? Minority. Are we together? So the law has put certain mechanisms always to protect the minority shareholders. The minority shareholders may go to court to sue the company for the decision made by the majority shareholders. And if the court will appoint an investigator to check on whether the rights of the minority shareholders have been violated. The court will appoint an investigator to check on whether the rights of the minority shareholders have been violated. When the court is appointing those investigators will investigate both the company and their members. Are we together? So hizo points tatu zote zinafanana. Appointment of an inspector appointed by the court, appointment of the inspector appointed by the registrar of companies, and the takeover bid. Are we together? So tumeelewa venye utaelezea hiyo point ya takeover bid. Utaeleza hivi that in a takeover bid, 90% of the shareholders are required to approve the takeover bid. The minority shareholders have a right to sue the company, and the court will proceed to appoint an investigator. The investigator will proceed to confirm whether the rights of the minority shareholders have been violated. And in investigating whether those rights have been violated, will investigate both the company and the members, and that one amounts to lifting the veil of incorporation. Are we together? Yes. And finally, fraudulent trading. Fraudulent trading. And fraudulent trading is where the business of a company is being undertaken with the intention to defraud creditors. It is where the business of a company is being undertaken with the intention to defraud creditors. The law, the Companies Act, has put mechanisms to protect shareholders and to protect the creditors against fraud. Are you together? And therefore, the law requires that if any business of the company has been carried on with the intention to defraud creditors during winding up, the court may lift the veil of incorporation and hold those involved personally liable. Those ones who have stolen money from the company will be held personally liable. Are we together? Yes. Fraudulent trading. If you do fraud in a company, you'll be held personally liable. Maybe you used the company to take some loan somewhere. Then later on, you swindled that money to your personal accounts. And then you say, no, it's not me who took the company. It's not me who took the loan. It's the company which took the loan. You'll not escape because that amounts to fraudulent trading and you'll be held personally liable. Now, those are by the statute. And we've said by the statute is what is stated in the Companies Act. Now, we look by, there are those ones that are not stated by the Companies Act. They are not stated by the Companies Act. But cases have been lodged in courts. For instance, where somebody was using a company to do illegal businesses. For instance, to do child trafficking. And the court ruled that at that point, that person should be held personally liable. So when you talk by the courts, this is the same as by the case laws. This is the same by the case laws, or cases that have been determined by court. Cases that have been determined by court. And one of them is determination of character. Determination of character. For instance, in a case where Kenya is at war with Somali, and it's an example, Kenya is at war with Somali. And a company, there's a company XYZ, and the members in that company, majority of the members in that company come from Somali. In those cases, courts have ruled that Kenya is also, that company is an enemy to the state. Are you together? Because its members, the people behind that company come from a country which is at war with Kenya, or which is an enemy of Kenya. Are we getting that? Yes. So where we are saying that in order to determine whether a company is an enemy in times of war, a company whose members behind it are foreign, who come from a country which is at war with Kenya, is also declared an enemy to Kenya. Are you together? A company whose members come from a country which is at war with Kenya is also declared an enemy of Kenya. So you declared that company an enemy of Kenya because of the membership of that company. That the membership comes from a country which is at war with Kenya. Is that understood? Yes. 2, the company is a sham. So the company is being used to undertake illegal activities. For instance, where we said child trafficking, money laundering, Sasa nyinyi mnatumia kampuni kuiba pesa, terrorism. Mnatumia kampuni kufanya terrorism. Nyinyi mtakuwa held personally liable. Are we together? Are we together? Yes. 3, where the company is acting as the agent of the shareholders. Yes. So what happens with this is that there are people who have formed companies. There's a book that discusses this in details, where somebody from Toyota Kenya had a contract with Toyota Kenya, yes, not to operate businesses of the, not to engage into any business with the competitors, for instance, Honda. Right together? But this person, sasa, maybe anauza magari. Akaambiwa, alikuwa anauza magari, akaambiwa asiuze gari za kampuni nyingine isipokuwa Toyota Kenya. So what he did is that because he wanted to also deal with the cars from Honda and other companies, he formed a company, and the person who became the director was his wife. The wife was the member, and Toyota Kenya sued him. Toyota Kenya sued him because he was dealing with the businesses of the competitor at a company, and the court ruled that this company was acting as an agent. The company was acting as an agent of the share, and it described the person as a shareholder of that company. Are you together? So where the company is acting as the agent, the company is not in law an agent of the subscribers. So you are using a company as an agent to undertake businesses of the competitor. Is that understood? Yes. Then the other one is protection of revenue, and protection of revenue is like KRA. So use the company to evade taxes. It will not be allowed. You will be held personally liable. But you answer kusema pana, mimi na kampuni, we are two distinct persons. No, the company will, the KRA will come for your own personal accounts. Sawa sawa? Yes. That's number 4. And prevent deliberate evasion of contractual obligation. Na hiyo ni kama tu hiyo ya. These 2 points, point number 3 and 5, zinafanananga. Because now this person who had formed a company to undertake the businesses of Honda, he wanted to evade the contractual obligation he had with who? With the Toyota Kenya. Do you agree? Yes, sometimes you form a company because you have a contractual obligation. Do not do businesses with these people. Then I form a company so that I start doing businesses with them. Right together? And then when you sue me, I say a company is a legal personality, a legal person distinct from the members. Then the court will lift the veil of incorporation. Tuko pamoja? That is clear? Yes. So now up to that point, you should know circumstances in which what does it mean by lifting the veil of incorporation? Lifting the veil of incorporation, let me ask you a question. Does it mean as disregarding the legal personality, the concept of legal personality? Lifting the veil of incorporation, does it mean as disregarding the concept of legal personality? It means the same. Is that true? It means disregarding the concept of legal personality. Can be disregarded, the legal personality, the concept of legal personality can be disregarded either by the statute or by the courts. By the statute, 1, reduction of membership below the statutory minimum. 2, group accounts. 3, yes, investigation of the company by inspector appointed by the courts, investigation of a company by inspector appointed by the registrar of companies, investigation of the takeover bid, non-publication or misdescription of the company's name. Si tumeelewa hizo? By the court, the company, to determination of the company's character. 2, the company is a sham. The company is acting as an agent of the shareholders to prevent contractual obligation of the, yes, to prevent deliberate evasion of contractual obligation and protection of revenue. Tuko pamoja hadi hapo? Yes. Now the other one is on partnerships. And when we talk about partnerships, we have said they do not have a legal personality. They do not have a legal personality. We also distinguished, so duties of partners, one is to contribute capital, to be accountable, to be honest, not to compete with the firm, and to share profits and losses. Rights of a partner is to participate in decision-making, to participate in sharing profits, and to be informed in case of admission of a new partner, and to inspect or access partnership records. Dissolution of partnerships either by court or without court order. By court, a partner may apply to the court for the dissolution of partnership under the following grounds. One is insanity, permanent incapacity, prejudicial conduct, persistent breach of partnership agreement, continuous carrying of business at a loss, and just a disputable ground. Just a disputable ground niyo inamanishanga continuous disagreement. Partnerships wana disagree. Partners hawasikizani hata waongeleshani. At that point, it can be dissolved through a court order. And without a court order, lapse of time. See, kama partnership tulikuwa tumesema itakaa miaka 2, time ikiisha tunafanya nini? Tunaifunga. Si ndio? Performance. Performance kama tulisema hii partnership tunafanya ABCD, tukishafanya ABCD si tunaifunga, si ndio? By notice of the partners, partner mmoja anaambia wale wengine bankruptcy, death and insanity. Hizo si gumu, si ndio? Is that okay? So that brings us to the end of the first topic. Any question? You are good, Sindio? Any questions so far? So we can proceed with topic 2 tomorrow. So let me see whether there is any question from the online students. I was not writing much. I hope, because you have the sound is too low. I was low. So